My Lords, I rise briefly to speak in support of at least one of the points made by the noble Baroness Lady Lister of Bertaset, and it is a point I have made before. Nobody is entitled, under any form of international law, to succeed in an application for naturalisation as a British subject. In fact, we as a country are not obliged to grant naturalisation, but Parliament chooses that we should do so. And in doing so, it sets, understandably, conditions. These conditions might relate to good character and how long one has lived here and things like that. And, of course, part of those conditions will include the setting of a fee that needs to be paid. And there are other immigration processes that people who are not British subjects may wish to apply for, which again may rightly and properly involve a fee. Nobody disputes that. The noble Baroness doesn't dispute that as a matter of principle at all. There are practical considerations, some of which she has explored in quite considerable detail in her remarks, about what the effects of those fees might be, and the noble Baroness Lady de Souza has raised the question of the effects, particularly in relation to people coming here with scientific qualifications and in the scope of education. And all of those are matters which are very properly the subject of public policy. And I tend to think that it is true that the Home Office is playing sleight of hand here to some extent, raising the fees higher than they need to be raised, or at least than can be justified by the work involved, as a means of trying to extract money from people who need to go through those processes. But it is ultimately a matter of policy. But there is a bigger sleight of hand going on, which is the point that concerns me, and that is the obfuscation we constantly see from the Home Office about the distinction between applications for naturalisation or other immigration processes, to which I have been referring so far, and applications for registration as a British national. The application for registration is an application not made by a foreign person for the right to be naturalised as British. The application for registration is an application that somebody who is already British should be recognised as such by the government and by the state. And that status of being qualified for registration arose towards I think it was legislated for at the end of the Second World War, because of the messiness and complexity of nationality and different national statuses that were left behind as empire began to dissolve. And it was recognised by government and parliament that you couldn't possibly make a list of all the different categories that might arise. You'd miss people. So there would be this safeguard for people who were entitled to be recognised as British subjects, British subjects, who would apply and demonstrate it on the evidence. Now, that doesn't seem to me the same thing at all. That seems to me the recognition of a right that already exists. And we of course, who don't have to demonstrate that right or can demonstrate it routinely, are perfectly willing to accept that some fee might be involved in that. We all pay a fee when we apply for a passport, and we begrudge paying fees, but we don't recognise that we don't think that's a wicked thing to do. So some fee might well be involved in registration. But a fee that is so high that it prevents people from exercising what are in fact their natural rights that have been recognised by Parliament, seems to me wholly odious. And the constant obfuscation of the Home Office in trying to merge these two and pretend that they're really the same is particularly, I think, almost bordering on insulting to the Parliament to a Parliament which created that distinction in the first place. Now, I will say, I see some modestly approving nods on the front bench, on the Labour front bench, but it is the case, I'm afraid, that in the past I've noticed that the Labour Party, although they might have some sympathy with this argument, never actually swings in behind it with the undoubted weight that they can bring if things were forced to the lobbies. And I think that's a pity, Because, as I say, I believe this category was introduced in the immediate post-war period by none other than the Attlee government. It is a Labour invention. So I would have thought that the Labour Party would be willing, really, on some occasion, if not today, to put itself in the front line on that. But we will find out. In the meantime, I really do urge my noble friend on the front bench to be honest and clear about these two wholly different categories and recognise that even though fees are appropriate for both, they are absolutely distinct, and the Home Office should stop trying to muddle us about them.